Welcome to the Employment Law and HR Podcast with your host, Allison Colley.
Hello and welcome to this episode 256 of the Employment Law and HR Podcast. I'm your host, Allison Colley. I'm an employment solicitor and HR specialist, and I run the firm Real Employment Law Advice, where, together with my colleagues, we provide advice and assistance to both employers and employees on all aspects of employment law. Thank you very much for listening to this episode of the podcast. If you are a regular listener, you'll know that our flagship service is our HR Harbour membership service, which for a fixed monthly fee, we can provide unlimited advice for employers. If you'd like more information or a no obligation quote, then please don't hesitate to get in touch. You can email me. It's alison@realemploymentlawsadvice.co.uk, or you can contact my office on 01983 897 003. And of course, if you're listening to this podcast as an employee seeking some advice and support, then again, my team are very happy to help you. You can contact us on the same contact details, email alison@realemploymentlawsadvice, and on our main telephone number, and we'll be happy to set up a no obligation initial call. In this week's episode of the podcast, I'm going to be covering a hot topic at the moment, which is settlement discussions and without prejudice offers as a way to resolve disputes. So, without further ado, I'm going to get into this week's featured content. Now, as I was saying, this episode of the podcast is covering settlement discussions and without prejudice offers. And the reason why I'm covering it in this episode of the podcast is because increasingly what we are seeing is that the availability of having without prejudice discussions or protected conversations is helping employers to resolve very difficult issues within the workplace. As people are becoming more litigious and understanding more about their rights, it can be very difficult to resolve issues quickly and smoothly without too much stress for all parties involved. So one way in which you can deal with issues is by way of a settlement discussion. But what exactly is a settlement discussion? A settlement discussion is a voluntary, confidential conversation with an employee where you explore the possibility of an agreed exit or resolution, usually by way of a settlement agreement. Now, I say that it is the possibility of an exit or a resolution because whilst in the majority of cases settlement agreements and settlement discussions do end in the termination by agreement of an employee's employment, it doesn't always have to be the case, and there are circumstances where you can resolve disputes with a settlement agreement and an employee's employment can continue. So it doesn't necessarily mean that a settlement agreement has to be the end of the employment, but in the vast majority of cases, that is actually what happens. Now, in order to be a valid legal settlement, so if an agreement is reached following a settlement discussion, this can only be completed by a settlement agreement, which has to fulfill certain specific criteria, and one of which is that an employee has to have legal advice on the content. So they have to have advice from a solicitor or a specialist legal executive in relation to employment to be able to sign off on the agreement. Or the other way in which you can legitimately resolve an employment dispute is via ACAS using a COT3 agreement. And if you resolve matters by way of a COT3, you don't have to have had legal advice on the content in order to complete it. Now, if you do resolve matters by way of a settlement agreement, it's only the employee who has to have had legal advice. However, given the legal nature of a settlement agreement and the potential consequences of getting it wrong, in my view, it's very important that employers do get legal advice on the content of a settlement agreement and that you don't just rely on a cut and pasted version that you've obtained from somewhere else or a previous employee's settlement agreement. You do need to get advice on it to ensure that you are best protecting your business or organisation. So why exactly would you consider using settlement discussions? Well, they're a really good tool to try to resolve disputes early on, so before things escalate. They are a good way of avoiding lengthy disciplinary or particularly capability processes. So capability processes in order to complete a fair and reasonable process has to take a period of time and give the employee the opportunity to improve. And this can take time, and sometimes employers would rather dispense of that lengthy capability process and offer a settlement, which can be better for both the employer and the employee in the long run, because the employee doesn't have to go through the stress of a capability or performance improvement process as well. It can obviously help to remove the risk of tribunal claims. And as I was saying at the beginning, people are becoming increasingly litigious and aware of their employment rights. And because it is free to bring a claim in the employment tribunal or to start the ACAS early conciliation process, we do find that people are more willing to do so if they feel that they've been treated unfairly. And so resolving matters by a settlement agreement or settlement discussion early on can help to alleviate that risk of a tribunal claim. It also, of course, reduces the amount of management time involved in dealing with the situation, and it can also protect the team morale. Because often within a team environment, if somebody's going through a disciplinary or capability process, or if there's a redundancy process, it can have an impact on the team more widely. And so dealing with it by way of a settlement discussion can help to avoid that. And of course, it can help you to reach an amicable closure of things, particularly where trust has broken down between employer and employee. So when you're considering what to do in relation to a settlement discussion, it's important to understand the two different regimes that can provide you with protection from the possibility that those discussions can be used against you in future in evidence. So the first thing is the Without Prejudice rule. So if you were to use the Without Prejudice rule and it were to apply to the discussion that you're having with the employee, then you wouldn't then find yourself having to defend a claim with the employee using that Without Prejudice discussion against you in evidence. Now, the Without Prejudice rule is a common law principle, and it's something that's developed over time. And in order to be able to rely on the Without Prejudice rule, there has to have been a dispute between the parties. So there has to have been either an actual or a reasonably anticipated dispute in order to be able to rely on that. In the absence of a dispute between you, if you try to rely on the Without Prejudice rules, then the employee could potentially use that as evidence in the tribunal or court later on. Now, if you are able to rely on the Without Prejudice rule, it does cover all potential claims or disputes. So in any type of claim or dispute, you can rely on the Without Prejudice rule to ensure that that information isn't used in evidence. But you must, of course, act appropriately in your discussions with the employee to be able to rely on that Without Prejudice rule. Now, alternatively to the Without Prejudice rule is the protected conversations, which has come into law a couple of years ago under Section 111A of the Employment Rights Act. Now, the reason the law changed was to enable employers to be able to have a discussion off the record with employees without there being an existing dispute or issue and without fear of those conversations being used in future. So it enables employers to take a pragmatic approach to dealing with issues with employees. And so you can rely on the protected conversation rules, even if there hasn't been an existing dispute. Now, it's important to understand that the Section 111A rules only apply in relation to unfair dismissal claims, so ordinary unfair dismissal claims. If an employee were to bring another type of claim against you in the employment tribunal, assuming that there wasn't an existing dispute, so you can't rely on the Without Prejudice rules, then they could potentially use that information or the settlement discussions against you in evidence, because under the protected conversation rules in the Employment Rights Act, you wouldn't be able to rely on those because they're not covered. And of course, in relation to those discussions that you have, in the same way with the Without Prejudice rules, you must act appropriately in how you deal with those. Now, there's been a fair amount of case law over the years about what amounts to improper conduct in relation to both Without Prejudice discussions and protected conversations. And in episode 239 of the podcast earlier this year, I covered a case, Gallagher versus McKinnon's Auto and Tyres, which was an employment appeal tribunal case where the employer's behaviour in relation to those discussions was scrutinised because the employee sought to rely on that discussion in evidence. So if you want to go back and listen to that, it's episode 239, and I'll pop a link in the show notes for you. So when exactly should you use the Without Prejudice rule? Well, you can use the Without Prejudice rule after a grievance has been raised, for example, indicating a real potential dispute, where there has been an ongoing performance dispute, or where they've accused you of doing something or not doing something, and of course where legal proceedings have been threatened. You can use the protected conversations rules where you want to terminate employees' employment without following a fair and full process, either because of performance or behaviour reasons, or where there might be a redundancy dismissal and you don't want to go for a full procedure or consultation, but rather approach individual employees directly to see if they would accept an offer to leave voluntarily. And of course, it would avoid the need to have a disciplinary process. Now, the risks in relation to protected conversations are, of course, that they could be disclosed in a claim for discrimination. They can be used against you in whistleblowing claims, breach of contract claims, or in relation to automatic unfair dismissal claims. So they can only be used to protect you from those conversations being used in evidence in relation to unfair dismissal claims. Now, whilst there is, of course, a risk in relation to other types of claims, if you did have that conversation, sometimes it can be worth having that conversation in any event and running the risk that that could be used against you if an agreement isn't reached than not. Because in my view, because of the way things work these days, because of employers taking a commercial approach and a pragmatic view to resolving disputes, even if the fact that you made that offer can be disclosed to an employment tribunal in future, as long as you've behaved properly in that conversation and the process that you've followed, and you haven't done anything that could contribute to the alleged claims against you, let's just say an employee's alleging discrimination and you've said something discriminatory in those conversations, it's not going to be as damning as you might think to have the employment tribunal know that you tried to resolve matters early on. So what I'm trying to say here is, even if an agreement isn't reached, the employee pursues a claim anyway and tries to rely on the fact that you made them an offer early on, I think that often that can be explained away in evidence by the employer in their defence by saying, look, we wanted to try to resolve things in a commercial and pragmatic way, and that's why we had that conversation. Now, of course, it'd be much better if that information couldn't be used in evidence against you, but what I'm trying to say is it's not going to be the end of the world. It's not necessarily the nail in the coffin of your defence if you have had that conversation and you do find it can be disclosed to the employment tribunal later on. Now, of course, you want to avoid this, and the best way of avoiding the need for the employment tribunal to know about that conversation is to avoid any improper behaviour. So, of course, if you have anybody within your organisation who deals with settlement discussions, that sort of thing, they should really understand fully how to conduct those in the most appropriate way, and they should follow a process in doing so. So in my view, in relation to conducting settlement discussions, the first thing to consider is preparation. It's really important to understand why you're having that conversation, what you're going to say. So if necessary, even prepare a script or bullet points so that you don't go off point or try to say things or get yourself into difficulty. So I would identify which of the framework applies. Is it without prejudice or a protected conversation or both? And then set out exactly what you're going to say. Agree who's going to attend that discussion with the employee. And I would recommend that you do bring another person to the meeting with you, because if there is any allegation of improper conduct, it's important that you have a witness there who can see what happens firsthand, rather than just go into that meeting alone. Then you need to decide if the employee is going to be given notice of the meeting and exactly what you're going to say to them about it. Now, my view is it's better not to give the employee notice of the meeting and call them in than it is to invite them to a meeting and tell them it's about something else. So if you are going to invite them to a meeting to discuss the settlement proposal, it's important that you're upfront and honest with them about what it is, rather than invite them to a meeting and then take them by surprise by changing the actual content of that meeting. And then, of course, consider if you're going to allow them to have a companion, and Of course, if you're inviting them to a meeting, then there's an opportunity to have a companion with them. But if you're just calling them in at short notice to have that discussion, it might not be as easy, but you could arrange for someone else to be there to attend and witness on behalf of the employee as well. The next thing is the meeting, how you're going to conduct that. And it's important that you approach the meeting in a calm and neutral way. The idea is to try to reach an agreement with them, something that's going to be satisfactory for both parties. And whilst they may not receive the news well to start with, as long as you handle it in a kind and calm and compassionate way, it can help you to resolve those issues or to avoid any further problems down the road if that offer isn't accepted. It's important that you emphasise at the outset that the whole process is voluntary, that it is without prejudice or covered by the protected conversations rules, and that you want to explore an agreed exit that would be in both parties' interests. And of course, telling them that they don't have to make a decision today and that they will have the opportunity to take the details away, the paperwork away, review it, and seek advice if they wish to consider the offer. I recommend that you keep those discussions concise and you avoid getting into the weeds of the issue. Sometimes employees will want to know exactly why it is, what's happened, how you got to this point. They will want to try to explain themselves or defend themselves in some way. And it's important to sort of keep those conversations to the minimum. So by saying, look, this really is the opportunity to consider a settlement to avoid the need to go through all of the details. Of course, if you decide not to accept the offer, then there will be the opportunity to discuss that later on. But for now, the purpose of the conversation is to provide the details for them to go away and consider. You need to ensure that you're presenting the offer objectively, so without any admission of liability, and avoid any blame, so avoid sort of he said, she said type conversations. Allow the employee to ask any questions about the settlement process or the settlement terms. As I say, if you invite questions, avoid getting into the detail about exactly why you've reached this conclusion. And then, of course, end the meeting professionally and give them the paperwork. Now, the reason why I say avoid getting into a conversation and answering questions about the purpose of the settlement, why you've got to that point, because sometimes if you do engage in conversation, then that's when you can run into difficulty in relation to, one, improper conduct or being alleged that you have behaved improperly, and two, in relation to evidence in future. So you might say something that the employee could use in evidence against you, for example, in relation to a discrimination claim. And then at the end of the meeting, I would give them the paperwork, so a covering letter and the settlement offer, so they've got everything in writing, and then give them a reasonable time frame to seek advice and come back to you on it. Typically, you want to be giving a minimum of 7 to 10 days, 10 days ideally, so that there isn't any allegation that you've behaved improperly by forcing them to make a decision quickly. Now, you can say, of course, to the employee that they would be required to give you that response in principle within a shorter period of time, and then allow them that up to 10 days to seek legal advice. And of course, confirm to the employee that they do need to take legal advice in relation to the agreement for it to be binding. Again, something that we often see is employees will receive the offer in the meeting and they'll say, yep, I want to accept it, I'm happy to sign it now, and they don't want to go off and seek legal advice. But it's important that you explain to them that in order to be legally binding, they need to have had legal advice, and that's why they need to take it away and get advice. And if you are able to, you can signpost them to local solicitors or specialists who might be able to help them in relation to signing it off. In relation to the offer that you make, you of course need to set out what the financial sum is that you're going to offer them, so the ex gratia figure or the termination payment or the compensation figure, however you want to term it. And of course, in certain circumstances, up to $30,000 can be paid to an employee tax-free for compensation. You need to have included your payment for notice or a clause in that agreement about notice and how they're going to work that. So when you are considering putting together an offer, one of the things that employers often negate to think about is that they actually have to pay notice pay as well. because ordinarily you don't want an employee to be working their notice. Now, there are some circumstances, so for example, redundancy dismissals where employees may be needed to work out the notice. But if it is a situation where you've had a dispute, for example, then quite often you don't want the employee to work out the notice. So you would need to make sure that you factor in the payment in lieu as well as the compensation payment. You can't wrap the notice payment into the compensation payment because it would be taxable. And then, of course, you need to include a contribution for legal fees. Now, typically, it's around £500 plus VAT. That there are some solicitors that will do it for as low as £350 plus VAT. Or if you're looking at sort of central London, you may be looking at £750 to £1,000 plus VAT for a solicitor to help with the settlement agreement. Other things to consider are about arrangements for the return of property. So if the employee has any property, things like company cars, phones, computers, paperwork, that sort of thing, how is that going to be dealt with? And are there any particular confidentiality issues that you want to cover off in the settlement? And any post-termination restrictions that you need to refer to? And of course, quite often these days, employees want to know what reference is going to be sent out about them. And so you can include some reference wording or a clause within the settlement terms that says that you'll provide a reference stating dates of employment and job title. When considering how much to offer, it does of course depend on the individual circumstances, what the reason is for the offer, what the litigation risk is. Has the employee already started a claim process or indicated that they're going to start the claim process? Do you think that there's substance to that claim? That will all impact on how much you actually decide to offer. When we're advising employees on settlement agreements, if the ex gratia payment or the compensation payment amounts to somewhere between 3 and 6 months' pay, in addition to their notice pay, then we would normally say that that is a good result to settle matters early on. Because if you are pursuing a claim in the employment tribunal, whilst there is a possibility of recovering more in compensation, there is a lengthy delay in terms of the employment tribunal process and getting to the outcome. There is also the costs if somebody takes legal advice in relation to that. And of course, if they were to obtain new employment within the time it takes to get to the final tribunal, then any compensation would be reduced by their new earnings anyway. So typically, if an employee is offered anywhere between 3 and 6 months ex gratia payment, then this is generally a good offer. So it might be that you're looking to pitch your offer around that amount. Now, in some circumstances, a 1 month payment for compensation would be sufficient, but it does of course depend on the individual circumstances, what the reason is and what the potential risks are. So some common pitfalls that we see in relation to settlement discussions are where an employer calls something without prejudice when no dispute already exists. So in these circumstances, an employer neglects the protected conversations rules, merely relies on without prejudice, and there isn't already an existing dispute. In those circumstances, the employee could rely on everything that's been said, although, as I was saying earlier on, I don't necessarily think this is fatal to a defence against a claim in the employment tribunal, but it's something that you'd rather not be dealing with, I'm sure. So do ensure that you are relying on the right without prejudice or protected discussions. Being too forceful or using threats. So in this circumstance, if you are very forceful in the words that you use or the approach that you take to those settlement discussions, you do risk that the employee will allege that you have behaved improperly, and therefore any protections that you might have from that being disclosed as evidence will fall away. And of course, it won't look good to the employment tribunal if you have been behaving that way and all of that information is then laid bare to the employment tribunal in your claim against you. Another way in which the employment tribunal could decide that you've behaved improperly is if you've given too little time for the employee to consider the offer. Time and again, I see employers who are giving employees offers and only giving them 1 or 2 days to decide, putting them under a lot of pressure to get advice and to think about it. In those circumstances, if the employee rejects the offer and pursues a claim, again, there is a risk that they could allege you behaved improperly. And we would recommend, like ACAS recommend, 10 days for reviewing and signing off on a settlement agreement. The next way employers often get it wrong is where they put the criticisms of the employee too strongly. So they go in very heavy-handed to those conversations. They don't present them in a neutral way. And again, this can also open you up to risk of claims, but also it can mean that the employee is already on the back foot and decides that actually they would rather not accept the agreement and would rather challenge you on what you've been saying. So there is merit to providing those conversations in a neutral way and not getting into the detail of things, because it can mean that employees are less defensive and more likely to agree to a settlement. And then it all comes down to the preparation. So not preparing sufficiently for that conversation or providing anything in writing. And this is where we find that most mistakes happen, is that employers do not prepare, or they allow somebody who doesn't have any training or understanding of the Without Prejudice and protected conversation rules. They have that conversation and then it leads to difficulty later on. So why I'm talking about common pitfalls in relation to settlement discussions, I just want to touch upon the excessive use of settlement discussions. Now, of course, I said at the beginning, the use of settlement discussions is becoming more frequent and is a good way of resolving issues to reduce management time, to save team morale, and to reduce the risk. But that being said, if you are using settlement discussions very regularly within your organisation, it can be a sign that there are other issues. So it can show that there are some fundamental cultural issues that need to be addressed. It can show some failings in management. So if settlement agreements are being used frequently to avoid difficult conversations or to cover up ineffective management, then that's when I think you need to take a deeper look into why they're being used and what's actually happening. So they are a good tool in your armoury, but they certainly shouldn't be used to resolve every single dispute or issue that arises with an employee. And if you find that you are in your organisation that they are being used frequently, then it would be worth having a deep dive into exactly what is going on so that you understand if there is a fundamental cultural issue. And of course, I see it quite often in organisations that do use settlement agreements excessively, that they do become the norm and are expected by employees. And this in itself can lead to more unnecessary grievances or disputes from arising. If an employee feels that an organisation will just give out a settlement agreement at the first sign of a grievance or the potential threat of a claim, then you might find that employees are raising grievances or raising issues in a way so as to invoke you to offer a settlement agreement, even if they don't have any substance to them. So yes, settlement agreements and settlement discussions are a good way to resolve disputes and certainly something that you should be aware of, but they are a tool to be used rather than an excuse, and the excessive use can cause difficulty. So just to recap then in relation to settlement discussions, as I said, they are a powerful tool when used correctly. You can have protection from those discussions being used against you and evidence under the Without Prejudice rules where there's an existing dispute, and under the protected conversations law under the Employment Rights Act in relation to unfair dismissal claims. Either way, whatever you're relying on, you need to ensure that you behave properly in those discussions and avoid any improper behaviour or anything that could be alleged as improper behaviour, because that could go against you later on if an agreement isn't reached. Clear communication and a fair offer are essential to successfully executing a settlement discussion, and I would strongly recommend that you always seek advice in relation to complex cases, particularly where there are allegations of discrimination or whistleblowing. If you would like any help in relation to formulating scripts or bullet points for discussions in relation to settlements, or you'd like any help in preparation of settlement agreement paperwork, so letters or the agreements itself, or you just want any guidance for your management in relation to this, please don't hesitate to get in touch. You can email me, it's alison@realemploymentlawadvice.co.uk, or alternatively you can contact our office on 01983 897 003, and myself or one of the team would be very happy to chat to you. I hope that you found this episode of the podcast helpful, and if you have any further questions or anything you'd like covered in future, then do leave a comment or get in touch. Otherwise, we'll be back in a fortnight's time for the last podcast episode of 2025. I hope you have a fantastic 2 weeks and I look forward to speaking to you soon. Thanks again for listening. Just want to finalise by saying I wouldn't be a lawyer unless I had a legal disclaimer. So I must just say to you that the information in this podcast is for information only. It's general review and a general update. It's always necessary to get specific legal advice about your circumstances. So please don't rely on anything that you've heard in this podcast. But please do feel free to contact me if you'd like further information or specific advice.